our name and our business name, that would be great. I'm going to start. My name is Bobby Vandenbalk. I'm the Member Services Director here at the Exeter Area Chamber, and I'm thrilled to have you all here. We're going to go this way, Dan.
My name is Dan Raposa. I work at Exeter Health Resources as the Advancement Director. I'm here today trying to learn a little bit to help my stepson, because I'm kind of a partner in a couple of restaurants in Sanford, Maine. So excited about the presentation that we're going to make.
Nancy Monta of Legal Shield.
Hi, I'm Maria Reyes. I just recently moved back to the area, and I was with the YMCA in Tulsa, Oklahoma for 15 years as a nonprofit director. Glad to be back.
My name is Erin Macaro. I do the marketing for Armon Networks, which provides outsourced IT for small to medium businesses. I have Delray Haggett, who send out cards.
I'm Holly Bachelor from Brook Park, Connecticut. We provide you with local beef and eggs and produce.
I'm Hunter Putnam with the Idea Garage.
And I'm Phil McDonough, the principal and broker at the insurance shop in the Seacoast. And I'm interested in getting my skills for business clients.
I'm Brett Emanuel, owner of Emanuel Engineering. I'm here to learn something, as usual. And where's Elizabeth? I did remember. You don't stop skiing when you grow old. You grow old if you stop skiing.
There you go. Well, you call me sometime, and I'll go with you.
All right. Wednesdays.
Okay.
And you notice he called you Elizabeth.
Yeah. I've been calling him by his brother's name ever since I ran into him down here, so he's all right.
We'll go back a few years.
Oh, and I'm Pam Cameron. I work for Ben Homes and Gardens, Monsanto Group, and I'm on the board of directors with Beth. I've been part of the chamber for, gosh, 11, 12 years now. So I'm interested to hear what you have on the estate.
I'm Kate Miller, one of the attorneys at Donahue Tucker Ciandella.
I'm Danielle Floyd. I'm an associate at Donahue Tucker Ciandella.
I'm Beth McDonald, and I'm a partner at Donahue Tucker Ciandella.
I'm Nicole Tibbetts, and I'm an associate at Donahue Tucker Ciandella.
I'm Patrick Collins. I'm also an associate.
And Gretchen Hayes.
And who's that?
The guy in the doorway.
You are?
I'm Mike Shidlovsky. I'm the president of your chamber of commerce.
As you count them down, congratulations.
Easy, Dave.
Gretchen, I didn't hear your name. This is Gretchen Hayes. Gretchen's a paralegal in our business practice group, and she is the one who is responsible for getting us all here, looking like we're organized, and providing this wonderful food. So, Gretchen, we can't do it without you. Thank you.
Thank you. Trying to break it off. So, just a couple of other little notes. Bathrooms, down the hallway to the left. Water. You need additional water right around the corner here. And we're going to get started in about 5 minutes.
I'd like to say we've put all this food out. There's food over here. Feel free to move around while we're speaking. That's not going to interrupt us. Just get food. Enjoy your lunch.
Steve Thorne and I are good friends.
Jump right
Steve
here.
Thorne, I need to do some reconnaissance on Exeter before I say something.
Can I get your attention? Are you guys all ready? Valerie, can you hear me down there? Valerie, can you hear me? Is this loud enough? Okay. Thank you all for coming. Welcome. We've brought some firepower here from DTC. As you know, we've got 2 partners and 3 associates, and half our firm is here. Yeah. We're going to talk today about estate planning for businesses, and we've broken it up into 2 sections. The first is going to be a discussion about an untimely death in a business, and the second is related more towards a planned succession plan. So you've survived and you've got a plan in place to pass on your business or to sell it. We have a fact pattern that we'd like to use to help explain this, and that's really going to be involved for Kate and I in this first part about an untimely death. The fact pattern consists of the following. Here, come on in.
Come on in.
Thank you.
And help yourself to food, please.
So the fact pattern is a business that's owned by two people. Their name is John and Sue. Sue has got her stuff together. She's got an estate plan. She's ready to rock and roll. And then John doesn't have an estate plan. He's on his second marriage, has kids from both marriages. Sue is married and has 2 kids. So with that, I'm going to turn it over to Kate to talk about the benefits of having an estate plan and anticipating Sue dying first.
Thank you, Patrick. Usually we kill off the men first, but in this particular case, Patrick wrote it, so unfortunately Sue is going to die first. So prior to dying, Sue did everything right. So she came to DTC, she saw Patrick or me, she talked about her family and her business, and we got things taken care of. So she mentioned that she is an owner, one of the 2 owners of an LLC. It's what's considered a member-managed LLC, and that's going to become important as we talk about things. So she and John are the 2 members of the LLC. They each own an interest in it, and it's member-managed. She did a standard estate plan for someone who's relatively young and doesn't have a huge estate, so there's no estate tax to worry about because her assets are under $5 million. So she gets a will where she leaves everything to her husband. I'm going to call him Sam, Sue and Sam. And she has all of her assets pretty much in joint ownership with her husband. So her house, her car, her bank account, joint with her husband with rights of survivorship. So that means that when she dies, he automatically becomes the sole owner. So nothing has to go through probate. It's very smooth. She has an IRA with some retirement money in it. She names, at our recommendation, she names someone as the beneficiary. So her husband, Sam, becomes the owner of that IRA on her death. Doesn't have to go through probate. It happens immediately. And then for the LLC, what we recommended that she do is certificate her membership interest. So a certificate is basically a piece of paper that shows something. So when you certificate a membership interest, it shows what the membership interest is for that person. So we see stocks for corporations, that's a certificate that shows an amount that's owned by a person. For LLCs, we don't usually do certificates because that's not required under the law, but it's very convenient in this situation because she can indicate on the face of the certificate that she wants it transferred on death to her husband, Sam. So she's got a certificate that shows her membership share, and it says right on the face of it, transfer on death to Sam. We do up a little blank affidavit that's in the file so that when she passes away, Sam can complete the affidavit saying she's died, death certificate, give that to John, who's the other owner of the LLC, and at that moment, the membership interest passes to Sam. So at this point, all the joint assets are now owned by Sam, the IRA is owned by Sam, and the membership interest is passed to Sam. None of it went through probate, and that's because she did a great job of getting all that stuff buttoned up ahead of time. Now what Sam and John want to do with the business, now that they're the 2 owners, is up to them. I mean, they could be the odd couple and it's not going to be a good fit, but at that point you have 2 people who have all the powers they need to make those decisions. They can continue the business. Maybe John can run it on his own. Maybe it's time to liquidate and they go their separate ways. There are all sorts of options, but there are no barriers or legal impediments to figuring that out and then carrying on the business or doing whatever they want to do with it. So it happens very quickly. It happens without a lot of expense. There's no need to probate the estate. You don't need to spend a lot of money on lawyers. So that's a good thing. And the most important thing is it's not a time of delay or real hassle for a family that's dealing with an unexpected death. So it takes that piece away and makes it much more simple. So that's the good scenario. Patrick's going to give you the bad scenario.
So my job is to try to scare you today, so you give us a call sometime in the next couple weeks. No, I'm kidding. My fact pattern here is that John has died first. He has no estate plan. He didn't do any planning beforehand. And then the question is, well, what happens? What is the consequence of not having a plan? And as Kate was alluding to, the failure to have a plan results in the business interest going through probate. And so some of you may be thinking, well, what does that mean? How does that actually manifest? And there are three real downsides. There are a bunch, but three of the major downsides to having a business interest go through probate. And the first is that there's a delay. There's at least a 3-week delay to have an executor, an administrator appointed to take over the estate and to run the business. And for that period of time, that 50% membership interest is dormant, essentially, and that could have some tangible impact on a business that is operating. There's also a at least 6-month period before the estate can be closed. So half of the business interest in this fact pattern will be in probate for at least 6 months, and likely between 6 months and a year. And that delay, again, can have a negative impact on the business. In addition, a typical estate plan would have that 6-month period and still have about a month before the administrator is appointed. Another hurdle that you have to overcome in probate when you have a business interest is you have to petition the court, the executor or the administrator has to petition the court to get authority to take on the business and to keep running it, which is another hurdle, another expense, another time-consuming process. So that's the first one. There's a delay. That delay also invokes expense, as Kay was mentioning, attorney's fees, court costs. So that's the first. The second is, without an estate plan, the membership interest is going to pass pursuant to the laws of intestacy, which is a fancy legal word that essentially means that there's a statute that determines where your assets are going to go. It may not be somebody that the surviving business owner wants to be in business with, or this the group of people. So in our fact pattern, John is on his second marriage, and he's got 4 kids, 2 from his first marriage, 2 from his second marriage. The laws of intestacy, without getting into too much detail with it, essentially all 5 of them are going to have a portion of this business interest. So the surviving owner, Sue, is now going to be somewhat technically in business with these other 5 people, which is probably not what she wanted. The other question then is, how do you get them out? So Sue survives. How's she going to get these other 5 people out of the business so that she can continue to go forward? And oftentimes that requires some type of liquidity. You have to pay for these people to get out, and you may not have funds available to do so. And if you had an estate plan, you might have bought life insurance, you might have had a buy-sell agreement, or knew that there was going to be some type of promissory note that everybody had agreed upon. Here, you're stuck, and the executor, the administrator, is going to have to get an appraisal, determine what the fair market value is, and the surviving owner, if they really want to get this person out, is going to have to come up with a way to buy him out, and that can be a difficult process. The third issue with going through probate is that it's public. And so your business, not only obviously the business that you own is you probably marketed it so you don't care that people know that you own this business, but a key downside is that you're going to have to get an appraisal and include that value on your inventory. And a lot of people don't want others, especially competitors, to know what the value of your business is and potentially what creditors are out there. So to avoid that, to avoid the publicity and the public knowledge of what your business is and how valuable it is, you can avoid probate through the ways that Kate had mentioned. Those are kind of the 3 big ones. There are other ones. So avoiding probate is one of our goals as estate planners when we're dealing with businesses, and it's never fun to go through probate. So with that, I'll turn it over to Danielle, who's going to talk about kind of the nuances of the estate tax, and if you are in that upper echelon, what estate taxes you may be subject to.
Thank you, Patrick.
So now that we've discussed what happens if you die with an estate plan, like Kate discussed, or without an estate plan, like Patrick discussed, I want to turn to what happens if you transfer your business interest at death in terms of the tax consequences. Now, the tax that I want to talk about is estate tax, because that's the tax that may become applicable or may become an issue if you transfer property at death. So there's, as we said, there's the two different ways to transfer property at death, pursuant to a will or an estate plan, and then pursuant to the New Hampshire intestacy statute if you don't have the estate plan. So when we talk about a transfer of a business interest at death, it's really important to consider who is going to receive the business interest. If the business interest is transferred to a non-spouse, then the business interest, be it in the form of corporate stock or partnership interest or interest in a sole proprietorship, will be subject to inclusion in the gross taxable estate. Now, what that means is it could be subject to estate tax. If an individual has a gross taxable estate of over $5.43 million, that's the exemption amount in 2015, then it'll be subject to estate tax at a 40% rate for the amount exceeding the $5.43 million. So certainly a significant tax. 40% tax is a lot, and something that you want to plan to minimize or avoid if possible through the proper estate planning. It's also important to note, as Patrick discussed, when you have someone who doesn't have an estate plan, the New Hampshire intestacy statute is going to allow some of that interest to pass to a spouse, and then depending upon your family structure, also to a non-spouse. So you'd have that situation where a portion of the business interest would be includable in the gross taxable estate, and then maybe subject to the tax depending upon your total gross taxable estate. The other situation is that you've left your business interest to your spouse. Now, in this situation, transfers of an interest in business or any other property to a spouse is not subject to inclusion in the gross taxable estate, which is a great benefit, and it's from what's called the marital deduction in the Internal Revenue Code. So that's a great benefit, but in order to take advantage of, fully advantage of the tax benefits of that marital deduction, you need to have the proper planning. The first thing that's important to note is a concept called portability. Portability allows an individual to use their spouse's unused portion of their exemption amount. So each individual has the $5.43 million exemption, and if you make the proper elections, then you can also use your deceased spouse's unused $5.43 million exemption. So jointly, the spouses could transfer $10.86 million in 2015 without being subject to estate tax. That is, of course, including lifetime gifts, because gifts do count against that estate tax exemption, and that's something I'm going to talk about in the next presentation. So that's a great benefit, the ability to use an additional exemption amount from your spouse. But in order to do that, what needs to happen is that you need to make the proper elections. That deceased spouse needs to file, their executor needs to file an estate return and make that election. So it's important that you see an estate planning attorney or an accountant to fill out that estate tax return. But it's also important that your estate planning documents are drafted in a way to take maximum advantage of both yours and your spouse's estate tax exemption amount, and that's something that we can address through proper estate planning. And that'll all help you avoid the problems of estate tax, which can be numerous. Again, 40% is a large tax, but it could result in substantial elimination of liquidity for the business. You have to pay such a big tax. Could be forced sale of assets, because the estate tax return is due 9 months from the person's death. So in order to continue to operate that business profitably, it's essential to have the proper estate planning documents to fully take advantage of exemptions and plan to minimize tax as much as possible. So now I'm going to pass it over to Nicole, who's going to talk about business succession.
Thanks. All right. Thank you, Danielle. I was going to start talking about internal succession planning, and then Beth is going to talk about external. So.
You may need to speak up to get our rally here.
Okay.
Over here, so try to reach to something beyond that back wall with your voice.
Okay. So the succession planning is basically how you plan your business might affect the business itself. Who you decide to leave it to could affect everybody. Am I loud enough? I'm loud enough? Okay. So you want to address this prior to death, obviously. So you want to decide who you're going to leave the company to at your retirement, and that should be through your estate plan, or in advance of your estate plan, you could train an employee to take over the business, and that would be a key employee. Ideally, it would be a gradual exit from the business, so you kind of groom somebody to take your place, take over the business when you're gone, and they could also continue on the goodwill of the business and make sure that it passes and keeps the business going strong. You could sell the business to a family member, or you could gift it. We'll talk about it a little later. But that could be a problem. We already mentioned that, or Patrick already mentioned that the implications of involving family members that aren't involved with the company, with the business. So you probably want to designate somebody that knows what they're doing and can work with the other members of the business in your absence. So what you want to do is train the key employee, give them some specific skills and management skills, make sure that they have the management skills in the business, and you can oversee them to make sure that they are going to continue the relationships that you've built with your clients, introduce the employee to customers and introduce them to contacts. That'll help ensure a good, smooth transition. And you should develop a steady and loyal clientele as you're working in the business to make sure that the business will continue once you're gone. To preserve the goodwill, you should probably establish a trade name or a trademark. I mean, it could be useful. And you could also have restrictive covenants, which are the non-compete agreements that I'll talk about in a second, with the key employees so that they don't leave and take the clients with them. You want to preserve loyalty by providing quality services to your clients, and that'll help generate repeat business and referrals. And your trademark or your trade name can create brand loyalty to the business so that people see the name and they want to keep coming, keep giving you their business. And that would help protect the goodwill as well from being taken by other people who saw your business and copied. So after you establish an LLC or corporation, this is under the assumption that you did, you could register it with the trade name with the Secretary of State, and that would put you in a better position because then it's registered and nobody else can use it. Or you can just have a trade name. That could be an asset to be sold to the business, so it's part of your sale when you eventually exit. So for a non-compete agreement, that would be for your key employees that you don't want to leave the business. They would have to be presented to an employee prior to the employee accepting an offer of employment. So they would protect the employer from the employee leaving the business and taking clients or establishing their own business in the exact same field and taking the same clients, basically. So you want to protect for the employee's departure, keep them from competing with you. And that would also help you maintain the value of the business if you have employees that continually work for you and aren't taking the client somewhere else. And you need to limit this agreement geographically, so it can't be too broad, and you need to limit it in time as well, so it can't be take too long. So that should be signed prior to the offer being accepted, but if it's for an promotion or something, if you want the employee to sign a non-compete agreement during their tenure with you, then you should offer them some kind of raise in order for this agreement to be valid. A non-solicitation agreement would be another type of agreement that could be contained within a non-compete, or it could be a separate agreement, and it doesn't have to be offered to the employee at the time of their offer, so that you can show it to them while they're already working for you. These would protect the business owner's interests as well, and they would basically stop the employee from taking the clients, from soliciting the clients, if they leave the business, and so they can't start a new association with this client in their new business from the former business owner. The agreements have to cover the employee's sphere of influence, so they can't be something else, that they didn't do. It can't be with somebody. You can't bar them from working later on with somebody that they never worked with, and they have to be physically within the proximity of the business itself. So they need to be specific kind of agreements. The other kind of agreement would be a non-disclosure or a confidentiality agreement, and that's to maintain the confidentiality of the business trade secrets and proprietary information, like client lists, or if you're a technical business, the technical kind of ideas. So signing a non-disclosure would be also later on in the time, or it can be contained within a non-compete offered before employment. So that one doesn't have to be signed initially, and it doesn't have a limit in duration. So you would need the express permission to disclose those kind of secrets if you signed one of those agreements. And they also need to clarify whether a worker's inventions would be the employer's property. So that is it for the key employee who you want to groom and prepare to take over the business. Those are your protections that you are offered to keep them working for you. And as I said, it's sort of ideal versus keeping a family member that might not know the business and getting them and putting them in charge of the business, or they could conflict with the other business owner. So the takeaway from this part would just be the gradual departure, training people, keeping up the goodwill of the business to keep it ready when you're ready to depart. And I'll hand it over back to Danielle to talk about gift tax. I think that was it, right?
So what I'd like to talk about are the tax implications of transferring a business interest during lifetime. And as you can imagine, that there's a couple different ways to do that. The first being that you could transfer your interest by a sale, and the second being that you could gift your interest during life. And the second one is what I'm going to talk about, the gift tax consequences of transfers that are gifts during life. So the first thing that may be advantageous and that a business owner may want to consider is implementing a long-term gifting program. Now this is advantageous for tax reasons and non-tax reasons. For non-tax reasons, if you've defined a person who you wish to transfer your business to, or multiple people, you can transfer control slowly over the years to those people without doing a significant transfer of control all at once. This allows for a smooth transition planning. The other benefit is the tax benefit. As we've said, there's a $5.43 million exemption, and that exemption is available for gift and estate tax purposes. So to the extent that you give more than $5.43 million during your lifetime, you'll be subject to gift tax for the amount over the $5.43 million at the 40% rate. Now that might seem like a lot of money to give away, and it certainly is, but to the extent that you use that $5.43 million exemption during life for gifts, you're eating into the amount of exemption that will be available for estate tax at death. So the estate and gift tax need to be considered together. But there is a very taxpayer favorable provision called the annual exclusion. The annual exclusion in 2015 allows an individual to transfer $14,000 per individual donee per year without eating into that $5.43 million exclusion at all. For couples, they can transfer $28,000 without eating into the annual exclusion at all. So that's certainly an advantage from the tax perspective that can be achieved by implementing a long-term gifting program where you transfer control slowly to a person or people of your choice and capture that annual exclusion benefit as well. Now, there also may be situations where it would be advantageous to give gifts beyond the $14,000 or the $28,000 for couples annual exclusion amount. And this may be situations such as when you expect your business interest to significantly appreciate in value. If you expect this, then giving them those business interests away is going to be advantageous because you won't be holding an interest that is increasing in value and therefore will be valued at a higher value for tax purposes. And also, again, when you want to give away portions of your business as far as a controlled transfer, you might want to consider giving away larger portions if you desire to transfer more control at one time. But there are some considerations that you must, they must speak to an estate planning attorney about or consider yourself. Always better to speak to an estate planning attorney regarding these complicated issues. A few of them are that the person who receives the property, if they subsequently decide to sell the property, if they receive the property by gift rather than a transfer from an estate or inheriting the property, then they're going to be likely subject to a higher capital gains tax rate. So that's a consideration, but when you compare the capital gains tax rate to the gift and estate tax rate, it's clear that gifting is still advantageous. Depending upon your income, capital gains can be between 15 and 20%. However, the estate tax and gift tax is 40%. So to pay more of the 20% tax to avoid the 40% tax still is a great advantage. You also want to consider the fact that if you give more than $14,000 during the year, then most likely you'll have to file a gift tax return. And it's good to seek the advice of an estate planning attorney to assist you with that to prevent errors. So some takeaways with regard to estate and gift tax is that when you're making your succession plans, they frequently involve important gift and estate tax considerations that you would want to consult with an attorney about. These rules are complicated and they're frequently changing. The Internal Revenue Code provisions change all the time, so it's important to continue to update your plans to make sure they conform with the current estate and gift tax law. And one thing that I haven't mentioned today, but it's also important consideration, is that when you transfer real estate, there could also be implications and assessment of the New Hampshire transfer tax, which is also in the future. Now I'm going to give the microphone to Beth, who's going to talk more about external sales to third parties.
Thank you. So the common theme here today, we hope that you're getting, is how to maximize the value of your business. And one way, generally a happy way, to maximize the value of your business is to sell it to somebody and take home a pile of dough. So I've made a mental note that I should always follow the estate planners because they kind of talk about death and bad things. It's very rare that as a business lawyer I'm the upbeat one, but today I'm going to bask in the sunshine here. So the third party, when I refer to a third party, I'm talking about somebody who prior to the sale transaction is not affiliated with the business, not a key employee, not a child, and is somebody who basically has come out of the blue. You don't know this person, okay? Who are the potential purchasers for your business? Well, it could be your competitor. I've done lots of transactions where someone is acquired by their competitor, okay? It could be somebody that either finds you by use of a business broker, or you find by use of a business broker, okay? And when you're using a business broker, you want to make sure it's somebody who actually has skill in that, or some experience in that particular industry, okay? I've seen numerous deals where you get a business, someone who holds themselves out as a business broker who, you know, they understand the real estate portion of the transaction, but the business part of the transaction is not in their wheelhouse. And so you want to make sure to maximize the value of your business that you're hiring the appropriate person, okay? And then you could have somebody who approaches you out of the blue to buy your business. That's not unheard of either. It's not common. It's not the way you would want to plan for it, but it does happen. So the most common structure for these sales come in basically two varieties. There are others, but for most of us, small business owners, they're going to come in one of two varieties. One is what's called an asset sale. So the assets of the business, tables, chairs, contracts, customer list, goodwill, all that stuff. The pieces that make up your business, okay? The other structure, the other common structure is what's referred to as a stock sale. And we've had a lot of talk today. Our fact pattern was a LLC. Because I'm a dinosaur, I'm going to stick with the phrase stock sale. But that's going to include the sale of an LLC membership interest. Plus I'm lazy and that just takes too long to say, okay? So you either have an asset sale or a stock sale. So the difference is when you sell stock, the company owns the tables, the chairs, the contracts, the logo, the whatever. It owns the assets. When you do a stock sale, you are selling the ownership of the company that owns the assets, okay? Probably you all know that, but I just want to make sure that that's very clear, okay? So, for those of you who are in a sole proprietorship today, you will not be partaking in anything called a stock sale. And you can have a trade name, doing business as XYZ, you are no more than a sole proprietor, okay? You own the stuff, you're on the hook, and that's what you sell, okay? The rest of you who are in LLCs, corporations, or whatever other type of entity, you will be able to make a choice, or at least think about which way you want to sell it. Very frequently, it's the buyer who's going to drive that decision, okay, and I'll explain to you why that is. Most sales are done as asset sales, okay, and the reason is because the buyer is getting the stuff that is used in the business, but is not getting liabilities. When you sell your business in a stock sale, they get the good, the bad, and the ugly. Okay? They get known debts. That's pretty easy. They can go through your books, see what you have for debts. They can check at the registry, see if your real estate is encumbered. They can check at the Secretary of State's office to see if your equipment and those sorts of things are encumbered and you owe money on them. Okay? But there's unknown debts. So an example, what would be an unknown debt? Well, if you run a convenience store, somebody's fallen out in the parking lot. Unbeknownst to anybody who operates the convenience store, this happens 8 months before the transfer. Okay? They have 3 years to bring an action. The action is going to be against, among other things, the business that's operating the convenience store. If you sell the stock, that goes with it. And the buyer, even though they were nowhere in the vicinity, they're going to have that liability. Okay? So that's where the rubber hits the road on the difference. So why would anybody in their right mind entertain a stock sale? Okay. I recently had one. We sold and it was a facility that makes spirits, alcohol. Okay. There's lots of federal licenses. Now, it's not that you could assign those licenses because, believe me, they want to go through everybody's underwear drawer to make sure that you're the right kind of person they want making and selling alcohol. However, we were advised by the regulatory folks that it would be easier. The review would be easier if it were a stock sale and not an asset sale. Okay? So that's an example of where you might do that. Another example, Many people rent their business location. They don't own the real estate. They have a long-term lease with somebody. It may be very important to the buyer to stay in that location, okay? And that lease might say something like, this lease may not be assigned, okay? But if it doesn't say, nor can the interest in the tenant be transferred, go ahead, have a stock sale. There's no prohibition in the lease. Contracts, just basic law, contracts are assignable unless it specifically says it's not. So if they don't cover it, it's not there, okay? So that might be a circumstance if the location is so critical. Anytime you're putting these transactions together, and you all know better than I, running a business, you're always making a risk-reward analysis of how you're going to do things, right? This might cost me a lot of money and gives me the perfect, but I don't have the money right now, so I'll take the risk. Or I'll do it this way, it's not perfect, but it works. So structuring these is never 100% in one direction. You're always going to have to make these qualitative decisions as you go along. So that's one. But generally speaking, most of them are asset sales, okay? So, let's see. All right, structurally, how do these things progress? The buyer shows up, and generally there's what's called a non-binding letter of intent. Non-binding because it's really, it's like your first or second date. You don't want to, very few people pop the question on the first or second date, okay? Dan, I'm sure you did. There's no question in my mind that you did. You strike me as a man who knows his mind right away. But we mere humans do not do that. And in business transactions, you certainly don't want to do that. So the lawyer's always going to tell you, make it a non-binding letter of intent. What are the sorts of things you're going to put in your letter of intent? Clearly, sale price. If you aren't starting your dating relationship knowing roughly where the number is at, you're going to waste a lot of time, spend a lot of money, and it's not going to go anywhere, okay? The type of sale, again, stock sale or asset sale, all right? You'll probably know that, it should know that. And there may be other unique situations that you want to detail in there, like if it's critical that the owner takes back debt, right, doesn't get all their money at the table, they're going to hold a note from the buyer. That's generally something you want to cover in a letter of intent. That's not something you want to inject into the deal a little bit later on, okay? Doesn't mean circumstances don't change and you think the bank's going to do it and then it appraises under the sale price and then you have a problem and then the owner takes it. You inject it at that juncture, but that's a big one, okay? So oftentimes the letter of intent is going to have a deadline by which you have to get into a purchase and sale agreement, which will be a binding contract. Now, there's a due diligence period. Everybody here, has everybody here owned real estate before, bought real estate? Well, there's generally some period of time within which you do a title search. You go to your bank. Okay, those are the building blocks for what became the in vogue term when the first banking crisis happened, which is due diligence. Everybody likes to do due diligence. Okay, that's what it is. You're checking it out. So sometimes that's done under the context of the letter of intent. Other times it's done once the P&S is in place. My preference, if it's going to be energy intensive, if it's going to require, imagine I have the seller, if it's going to require my client's accountants or me to be involved, so my client is starting to incur some expenses, I might want to do that under a P&S so that I've got some deposit money. So I make sure I've kicked, they're not just kicking the tires. They really want to be in this deal. So there's nothing like a deposit request to figure out if somebody's kicking the tires, okay? So in any event, during the due diligence period, you're going to have to disclose a lot about your business. And I have represented lots of sellers of teeny-weeny sole proprietorships all the way to companies that got sold to publicly traded companies. And I'm never disappointed at my anticipation that we're gonna get surprised. It always happens. Something comes up. And so what I would say is, as you're planning to sell your business, take a good, hard look in the corners, under the bed, here and there, and see if I were buying this business, what would I be concerned about? Oh, Joe's got a workman's comp claim against me, okay? I've got somebody that I'm not so sure they're an independent contractor, but it's working for me and nobody's complaining. We'll keep going with that, okay? Any of those sorts of things where you've made a risk analysis and you've made your business decision, you want to maybe take a second look at those. Your buyer's going to look at it, and you may end up having to address it at that point. And you don't want to start hemming and hawing at that point and acting surprised, because they're relying on you to be disclosing a lot of stuff in order to get to the closing table. So I think a little bit of a pre-due diligence by the seller, even before you put the thing on the market, is the best way to go, okay? It might cut down, I said might, cut down on the expense of the real due diligence, okay? So the sale agreement, and I know we're kind of bumping up against the time, and I'm sure you probably have some questions for these other smart folks. But the sale agreement. So some of the things that you're going to need to detail. If it's an asset sale, you're going to have to list what you're selling. It can't be my business, okay? Because if they think they're buying 7 trucks with 8 special things on them, you're going to need to detail that. Okay, so you're going to have to be very organized about what it is you're selling. In a stock sale, you will need to be equally as organized about the things that aren't going, because if you don't specifically exclude assets, they're going. Okay? The big one, the principal's car. That's always the one. After 25 years, I've figured out what's the first question asked. Does the company provide you a car? Yeah, okay. 9 times out of 10, the answer is yes. So I always try to pretend I'm smart and say, oh, well, we're going to exclude your car, right? Yes. We're going to exclude your personal computer because they don't want all the stuff on the computer to go. Yes. Okay. So if there's stuff you want that's in your business, it's, and certainly there's tax benefits to having it in the business. But as you get ready to sell, start thinking about what's important to me to keep. Okay. There are going to be things that you're going to sell that are going to, as I mentioned, the lease for one, okay? When you sell your business, if you don't own where you're located and that place is mission critical, you're going to need to interface with the landlord, and you're going to have to get their consent to assign the lease, because I would say 9 times out of 10, landlords put in some clause in their lease that says it's not assignable. There are other contracts, and it's always, the toughest ones for me are always these stupid software contracts, right? You have a software package, and good luck finding the guy who's going to sign off on it. But most of the time they just say, oh, the heck with it, I'll just buy my own package, okay? But that's okay if you're talking about Microsoft Word. It's a whole nother thing if you're talking about a proprietary license in a very industry specific, in a CAD program, something very specific that you might use. Or I've done a bunch of inns and hotels recently, and their reservation systems are, that's a big deal. Because when Joe leaves and Susie takes over the inn, those reservations, you hope, continue to come in. So that's one of those ones you got to make sure gets transferred. So I always say to my client, where's the stuff you don't own that's important in this business? What don't you own that you use? And let's figure out what we need to do for that, okay? Sale price, I always stay out of that. I mean, you have a better idea. Frankly, I think your accountants, if you regularly use a CPA, they can help you. The business brokers, provided you get one that's familiar with your industry, they can help you. And then you clearly know what your business is worth, and the buyer will come with an idea as well. Asset sale, you've heard about goodwill. Okay, Nicole talked about logos, and she talked about trade names, and she talked about your customer list. Okay, that's all about goodwill, and that's kind of over the years I've learned that's kind of a intangible thing to identify. You can't go look that up in Kelly's Blue Book. okay? 40 years in the business, you know, worked 18 hours a day, gave blood every day. You know, what's the value of the goodwill, okay? But there's an allocation process for tax purposes, and the buyer and the seller have competing interests on how that allocation happens. And I'm not a tax attorney. I bow down to Danielle for her efforts to become one. I do know that it has to do with depreciation, and the buyer's going to want, you know, things that they can depreciate quickly, I think, higher. So I always, over the years, after having gotten bloodied in a bunch of these, I have tried to force my client and the other side to get it done as part of the purchase. At the last moment would be the purchase and sale agreement. We attach a sheet and this is the allocation. Because what you don't want is to be on the eve of closing and suddenly you get the maneuvering. And that can have a big impact on the tax consequence, i.e. what you put in your pocket when you sell your business, okay? So that's one, when you go to sell, make sure you're on top of that. Closing dates. Think about when is best to close. We just sold a business where the owner has an equity line on his house, and to keep the business running through the winter, the slow period, he's drawing on that equity line to beat the band, okay? Long about June, he's whole again. And then the gravy comes after that, okay? He didn't want to sell until June because he's got to fill in the hole, okay? That's just one example. People do all kinds of crazy things and they have all kinds of different reasons of why it's important. But as you're thinking about selling, when's the opportune time? When's the best time for you? Okay? Let's see, I promise I'm going to stop. Another thing, when you're selling your business, it will create a little bit of a restriction on you because between the time you agree to sell your business and the time you actually sell your business, you're going to keep running your business. But now you've got somebody who's got an interest in getting the same business they agreed to buy. And so typically there's going to be a covenant that's going to, at a minimum, say you're going to continue to operate your business in the usual manner. I've actually seen it where real estate leasing business, you can't enter into any leases unless I, the buyer, approve them. Or you can't buy any capital items if we're doing a stock sale. No capital purchases over X without my written approval, okay? So you want to think about that as well. We've talked about key employees in the context of them being a buyer. But you all know, as I made a point to tell you how important Gretchen is to us, or to me, key employees make you or break you, okay? And they're going to make or break the success of your business in the buyer's hands, maybe, okay? So you might say, Joe's been with me forever and I don't need a non-compete because he's never going to compete anyway. But when you go to sell your business, that business, the buyer's going to want to make sure that Joe, who 50-50 might like the new guy, might prefer the old guy and hate everything about the new guy and become completely impossible in the workplace. He doesn't want Joe to go, okay? And so part of the goodwill, making sure those customers stay and there's nobody pulling at them, is you might have to go and, before you sell, get Joe to sign a non-compete, okay? Better to do that before you put it on the market than when Joe knows you're selling, because Joe might all of a sudden go home and talk to his wife, who might not like you so much because Joe spends so much time at work, and she plants the idea, this is worth a lot of money to this guy or this gal, okay? That happens, okay? You also, if you're going to have a non-compete, you want to make sure it specifically says you can assign it. You want to make sure, so there's dispel any concerns that it won't be, somebody's going to pop up later and argue it's not assignable, okay? Because that's definitely part of your goodwill. And then of course you may want to continue to work, It may be important to you to continue to work for some period of time, and so you may want to negotiate an employment contract. Conversely, the buyer may want to negotiate only a consulting agreement where they want to be able to use you when they want to use you. So these certainly are not all of the provisions that are involved. The last one, which is in my section, I'll hit it very quickly because, again, we are up against time. Financing, the purchase of a business. Small businesses very frequently are difficult to bank. You know, bankers, I hope there's no bankers here. I represent some great bankers. Our firm does a lot of work with a lot of really good bankers. But what bankers in New Hampshire really know is real estate lending. Okay? Other kinds of lending, it's not as common, and so it's not as comfortable. And bank lending is all about risk analysis, okay? So if you have a business and it doesn't have bricks and mortar, you may have a hard time finding a buyer who can go to a bank and get financing to do what I think is, because lawyers are always risk averse, I think it's better to get all your money at closing and run away than it is to be kind of in and kind of out, okay? I don't like that risk profile. But I'm a realist, and all my clients are realists, and sometimes the only way you can put the deal together is the other two. You don't bank it, you don't bank all of it. You bank some of it, and then the owner takes back some. Okay? Or, my nightmare scenario, you bank all of it. Okay, you act like the bank. So your entire retirement is now contingent, or your value of your business is contingent on that guy succeeding. Okay, and you're in Florida or wherever on the ski slopes, wherever you prefer to be. Okay, so, but it is what it is, and if you want to get your value out, generally participating in some of the financing oftentimes is a way to get a little more value out, frankly. So anyway, that's it. We're happy to take questions or comments at this point. Anybody got a question? Fred?
What's the difference between solicitation agreement, rather non-solicitation agreement, and non-compete agreement?
Since I have the microphone, I'm going to hit that for you, okay? The non-compete is generally you're not going to compete with the business, and oftentimes it's you know, within a certain area. Non-solicitation, I've heard them referred to in two cases. One is you're not going to solicit the customers of this business. That's one. The other one is you don't want them rating your employees, so they can't solicit your employees. So your second,
The buyer?
no, the key employee. So you have a second in command, right? You've been grooming him or her, but you have a non-compete. If they leave, they may go outside of your non-compete zone, so you can't get them that way. And all of a sudden, they start picking off your key employees. Okay, so that in my mind, that's that's what I would refer to as a non-solicitation. Yeah, normally it's one agreement. You just draft it all up together.
So if you haven't done this prior to hiring this person,
You got to give them something. You got to give them consideration. And it's, you know, again, I've been at this 25 years. I'm not going to ever tell you what the right consideration number is. We are all going to guess, and we're only going to find out it's not the right number if they challenge it and win. I would say it's more than $1, you know, and it's probably less than $1 million. So somewhere in there, we could find something. Or I think I've seen where people have been given a week off in exchange, you know, paid week off, or something that's of value to them, because in order to have a binding contract, you have to give somebody consideration, value. So.
can it be something other than cash or a vacation? Can it be stock?
Oh gosh, that's even better, I think. Now,
Don't offer them.
but as a business lawyer, I would say, don't give them stock. Okay? Because if what you're thinking is I want to get this agreement in place because if I sell my business, it will preserve the goodwill. Okay, now you got another guy who's got the rights to say, no, I don't want to sell the business. You got another seller. You're not necessarily controlling the sale. Okay, now there's what's called dissenters' rights. It's been a while since I looked at the statute, but it used to be, if you could take that, from them, but you had to pay them the fair market value of their stock. And it may come at a time when you're selling to this guy, but you don't have the dough to take this guy out. So anytime you offer ownership in your business, you lose some control. Contractually, you can work around it. So for the stock, I've seen you'd want to have a shareholder agreement. And in that shareholder agreement, you would want to put something that are called tag-along rights, so that if you sold, his rights have to go with yours. And if you're giving them, you're gonna, he's gonna get, if there's 100 shares and you sell it for 100,000 and he's got 2 shares and you've got 98, he's getting $2,000. But that you can, contractually, you can work that out, but don't give him the stock first. Yeah, I think, you know what, I know it's the thing. I've spent a lot of clients' money, okay, trying to figure out ways to reward employees that wasn't cash. And I always wonder, at the end of the day, would it have been better for the employee, if that's who we're trying to benefit, to give them the cash? And it would have certainly been cheaper than me chasing around trying to figure out some other way to do it and still protecting the owner. That's just anecdotally, sometimes $500, I might do it. We'll be all set.
Cash, dependent on the size of the business, or is it just dependent on the money, his annual salary, or any?
There's no rule of thumb. That's the problem. I'm sorry, and I know that's not helpful to you, but I mean, I would say it's got to be something more than a nominal amount, because it would be, if they were going to look at the value, if this guy left, how would that, and started to compete, that's not $50. It might be $50. I mean, if it were me working for you and I said I'm going to leave and compete, no problem. $50 to do it, because there's no way I could effectively compete. But you wouldn't hire me, I know. But anybody else got a question? Yes.
Yeah. One of the things that I see that, from my perspective, is important in succession, especially in the insurance, is providing the coverage, the insurance, in order that your succession planning occurs with the key employee.
Right.
Because and protect against the key employee, being in business with a key employee's wife who has no idea what's going on. Or just to make sure that you're covered if you have to make a different plan on the unexpected death.
I think Patrick, I handed him the microphone because I do recall he mentioned the insurance as a buyer, which is...
So you touched on a nerve that is the common in this circumstance, which is how do you get enough liquidity to effectuate your goal, which may be to buy this person out or to give them something. And oftentimes the simplest way to do that is to buy a life insurance policy, a whole life insurance policy that grows and then has a benefit whenever what circumstance arises, and then you can pay that out. The other way to do it, which it doesn't create liquidity, but it's a way to enter into essentially a contract with your key employee to say, if and when I retire, you and I are agreeing now that there's going to be a promissory note with this interest rate over this amount of time that's going to be used as the vehicle through which we're going to buy you out. It's not liquid, you're not going to get it all in one lump sum, but you've agreed to the mechanism through which you're going to do that.
Right. And from my point of view, you still need to worry about the insurance, because if he dies all of a sudden, then that next point is your succession plan is going to help.
Exactly. Right, exactly.
Yeah, that's key man coverage, right? Isn't that kind of loosely what you're talking about there?
Buy-sell agreement, with an insurance thing to make sure. And you can do it, and you know, lawyers are employed to make sure that the contract is the way I want it.
Just a quick question about the facts, the notion that we're talking state of New Hampshire, we're talking LLC, subchapter S Corp in another state. What are maybe the top 3 little things that if this were Maine, and it's an S Corp, and I mean, are there some things relative to what you said in the last hour?
S Corp, just so you know, I'll just jump on that. S Corp is an IRS classification, so that doesn't vary from state to state. That's a federal tax treatment, okay, is an S Corp. An S Corp and a C Corp, from the corp side as a corporation, they're exactly the same. One is just doesn't elect the S treatment, okay? Now you've erected the Maine New Hampshire border, God knows where that is exactly, down there in Portsmouth, but now that you've put it up, corporation law is different state to state to state, okay? Now, the general principles that we're talking about today apply to an S Corp in Maine as they do to a LLC in New Hampshire, basically.
Okay. Same with the probate stuff, estate stuff.
You know,
That can vary.
yeah, that varies. That varies state to state. But there's no doubt that Maine has an intestacy statute, okay? And there's no doubt that you can contract with your business partner or by plan of a better way to do it. Now, whether the widow gets all the business interest upon your death, or the widow gets the first $50,000 and the kids all get an interest in Maine under the intestacy, that'll vary. We really don't know. But there's no doubt there's a way you can do both of the concepts we've talked about. One is plan, and one is hit the windshield when it happens. Okay?
Another key distinction, Dan, is that in New Hampshire is the only state in New England that does not have a state estate tax. Maine does. Mass, all the other ones do. So there is a more tax-based nuance to an estate plan.
On top of federal state.
On top of federal state, exactly, yeah.
And the exemption is way lower. That's the key thing. So in Maine, the exemption amount is $2 million. So if you've got a couple businesses, plus a house, retirement
That's
assets.
what my son,
Right.
2 restaurants, a home, a rental home.
Right. So he could easily hit that without being aware of it, because as Danielle mentioned, the estate tax is very inclusive. It's everything you could possibly control up until the second you die, which means all your life insurance, it means all your retirement assets, it means it's every possible thing that you own. So that's a very important consideration for estate planning for people who have businesses, real estate outside the state of New Hampshire.
Okay, thank you.
I would say, and calculating the state, you also have to consider there's inclusions for if you make transfers and you retain
certain interests in those transfers, there's also the potential of inclusion of those assets as well. So something you want to be aware of.
Any other questions or comments? We want to thank you very much for taking the time and joining us this afternoon.